Greetings of peace and joy. I'm Ronel Gopio, a BSBA major in Human Resource Management student at AMAOed. Today I'll be presenting my labor case defense study in compliance to the requirements for my labor law and legislation subject. A presentation analyzing the labor case between the Cebu Portland Cement Company, the petitioner, versus the Cement Workers Union, and the Court of Industrial Relations as the respondents. As shown on the screen is the outline of my presentation, starting with a short summary of the case, facts and issues, followed by claims and counterclaims made by both parties, the different court decisions relating the case to the current labor regulations and legal practices, and last is my ideas, personal opinions, and conclusions on the case. To start is a short summary of the case. The labor dispute arises when about 300 workers in the plant of Cebu Portland Cement Company, affiliated with the union, staged a strike on March 24, 1961. Allegedly due to the company's dishonor to the collective bargaining agreement and provision of a monthly collections of 1 peso from non-union member employees, where at the same time the union filed the charges for unfair labor practices against the company at the labor court. The company also had filed a charge of unfair labor practices against the union for staging the strike, leading to violence, 1 death, and injuries to other employees. With the ongoing settlement of the case, the labor court issued a return to work order where strikers able to work again on July 6, 1961. Then followed years later on by a single decision for the 3 cases on November 6, 1964, declaring the strike illegal, and the charges filed by both parties were dismissed. The labor court also had found that there was discrimination against the union members, particularly on the assignments of shifts and working days. Those discriminated workers were paid later by order of the court, which had also pointed out the company's memorandum of April 4, 1961. This was issued during the pending labor dispute that requires its employees to avail monthly sick and vacation leaves, stated as violating the court's return to work order, resulting in the order of restoring accumulated leaves of the affected employees. The company then had filed a petition at the court en banc for the review on decisions of the lower court. This was denied due to the insufficient reasons and proofs presented by the company. However, a modification of the case declaring the petitioner not liable of paying the differential salary awarded by the lower court to the 6 employees named in the complaint, stating no discrimination was employed by the petitioner on the appointments of their present positions. Therefore, decisions appealed is affirmed in all other respects, and the case were remanded to the labor court for compliance as stated herein. Moving on to the facts and issues is fact number 1. On March 24, 1961, about 300 workers in a Cebu Portland cement plant in Naga, Cebu City, affiliated with the union, staged a strike allegedly because the company refused to honor the collective bargaining agreement and the union's collection of a monthly agency fee of 1 peso from non-union member employees. The issue is that, does the company whom had staged the strike liable for the action? And what would be the applicable punishments if they are proven guilty? The employees, if proven guilty, will be punished either by suspension or with the last option of termination from employment. However, if the strike is due to the company's negligence on its responsibilities, the act of the strike should be considered a valid reason exempting the employees from any form of consequences against their committed action. Fact number 2. The company were operating at a loss prior to the strike had decided to cut off incurred losses resulting to reduce the workers who will work on Saturdays, Sundays, and legal holidays. But by giving grant to most non-strikers, as well as force employees to take their sick and vacation leave entitlements to save cost. On fact number 2, the issue is that does the company has the rights to compel without prior notification to employees? What will be the result if the company had communicated the changes in proper to the employees? Would the employees agree or disagree in case the company proposes changes? Yes. In the first place, the company as an organization has the rights to compel or implement rules and changes. But this should be properly communicated to the employees, or it may fall into the category of a larger conflict which most of the time resulting to a strike or a complaint of unfair labor practices, especially if it severely affects the worker's condition and status. And in the case of a financial issue with a company, employees would certainly understand the situation. Fact number 3. The Cebu Portland Cement Company, on filing a petition at the court in bank alleging that the Court of the Industrial Relations had gravely used its power in misjudging the case. The issue is, was there any fault on the judgment of the labor court, or if there is, what would it be? The labor court, in my own idea, was just protecting the rights of employees, and may have found out the company's negligence. In assumption to the current case, the company was just focusing on how to reduce its cost, but forgot to look after their employees' welfare. The next part is the claims and counterclaims made by both parties. On the claim of the workers' union, a case for unfair labor practice was filed at the labor court by the workers' union alleging the company's refusal to the collective bargaining agreement and refusal to bargain with the employees. In addition to that, the collection of agency fee to non-union members based on the law is not legal unless there is such an order to do so, or unless it is mutually agreed by both parties and documented in a memorandum of agreement. For the claims or counterclaim made by the company, a case was similarly filed by the company at the labor court alleging the union for staging the illegal strike, for employing threat, intimidation, and violence resulting to one death and injuries to other employees. Another one is a motion for reconsideration filed at the court en banc to review the judgment of the labor court. The company has of course the rights to request for a review on decisions and can be acquitted if proven that there was a fault on the previous judgments. Proceeding on part 4 is the different court level decisions. The question is, how does the different court level decisions contributes to the sound judgment of the case? The first factor is the transparency that both courts had employed during the process of solving the case. It is very important that on conducting investigation, transparency is being applied in order to come up with the best of fair judgment that the court could have decided. On factor number 2, commitment in reaching the right and best decision that of course would protect the right of workers and the company's interests. With commitment of conducting a thorough and justifiable investigation and analysis of the case, the court would of course lead the way to a decision that will protect the company's interests and its employees' welfare. On the case modification, I strongly agree in terms of the appointment on the union. The positions or ranking should not be a question or a reason for discrimination, whether it is for long-term or a permanent appointment on the organization. However, I disagree on the side of the company handling the appointment of the union officers, which should be handled only by the union and its members. Proceeding to Part 6 is relating the case on the labor law regulations and legal practices. The case at hand can be related on the following according to the Labor Code of the Philippines, at present on the Bureau of Labor Relations, Department of Labor and Employment, question number 11, that says, when may a strike or lockout be declared illegal? A strike or lockout may be declared illegal if any of the requirements for valid strike or lockout is not complied with. It may also be declared illegal if it is based on non-strikable issues or if the issues involved are already the subject for arbitration. During a strike or lockout, when either of the parties commits prohibited acts or practices, the strike or lockout may be declared illegal. On the labor case study, the strike is considered valid because it is arising from an unfair labor practice reason. But in assumption to that, the union was not able to meet the requirements needed to prove that it is done legally. The labor court as well had declared it illegal due to the lack of supporting documents, proof to be considered a legal action. Next is the Article 282 of the Labor Code stating that an employer can terminate an employee for just causes which could be any of the following. I have taken the point of a serious misconduct or willful disobedience by the employee of the lawful orders of his employer or representative in connection with his work. The strike can also be considered as a serious misconduct on the side of the employees, but in consideration of the main issue, it can also be interpreted as an action of miscommunication. And from my own perspective, the issue can be solved if both parties will cooperate with each other. Last is the Article 264 of House Bill number 2541 stating that any worker whose employment has been terminated as a consequence of any unlawful lockout shall be entitled to reinstatement with full back wages. Any union officer knowingly participates in an illegal strike, and any worker or union officer who knowingly participates in the commission of illegal acts during the strike may be declared to have lost their employment status. Under pain of immediate disciplinary action, provided that a mere participation of a worker in a lawful strike shall not constitute sufficient ground for termination of his employment. Immediate disciplinary action, even if a replacement had been hired by the employer during such a lawful strike. It is clear that even an employee who had participated in such strike on employment, termination is always the last option, as there are still factors that needs to be considered before finally dismissing a striker permanently out of service from the organization. The striker may be dismissed or may be reinstated to the service of employment, which will depend on the scope of the committed acts against the company. The last part is my ideas, personal opinions, and conclusions on the case. Number 1. There is a lack of communication on the part of the company, where A, when the issue had arisen, is the failure of conveying information to their workers, for the workers to be aware of the recent developments, especially if this affects their working conditions. B, it is the company's rights to implement and change any rules as an organization relating to the employment of workers, but such rules and changes should be properly communicated and mutually agreed. This is in accordance of meeting the requirements of both sides or both parties. C. It is the company's responsibility to ensure the welfare of their workforce, while ensuring the company's survival, and even in times of financial shortage, the company still has the responsibility to carry out and pay their financial obligations to the employees, except when there is an authority from law to withdraw or suspend such entitlements and benefits. If I, as the company, my responsibility to my employees will never end or will never stop as long as I employ them. Even in tough times, I will still be responsible to compensate them. Number 2, there is a lack of communication on part of the employees. Where the strike was being done is the assumption of failing to convey information from the side of employees asking the company first for an open forum prior of conducting such action and getting a much better solution on their concerns. B. It is the employees' rights to go on a strike, but of course it is also their responsibility to first find a peaceful means to protect the interests of their co-workers. And C. It is the responsibility of employees to at least understand and respect for whatever made decisions, more especially if their employer is on the current situation involving a lack of financial capacities, resulting to cutting of incurred costs. An open door policy where everyone can express and ask their questions and concerns is a much better option or a much better rule, especially in part of communicating with both parties or with employees or employers. Number 3, there is a negligence on both parties. In A, where the management of the company was only focusing on reducing the incurred cost, that they had completely disregarded of getting the opinion of their workers in regards to the financial standing and to seek a much better options. B, where the company, on its faulty side of failing to perform its responsibility to communicate, was also appealing for the rights in order to protect the company's image and business interest. However, by doing so, it resulted to a larger consequence. And C, where the workers with the union staged a strike was focusing on the appeal of their rights and interest as workers, where it resulted to a larger consequences, leading to disturbances to other non-striker employees, injuries, or worse, it can cause death. All of the neglected actions from both parties can actually be solved without going for a dispute or at the labor court, but by just communicating with each other, by cooperating, and a deeper understanding. In my own way of concluding the case is first for the company's management. The board of directors of the company should have changed the management personnel who were presently managing during the issue, as a management staff should not just focus on the financial performance of the company, where he or she is responsible to ensure greater financial returns while maintaining the harmony, uniformity, and peace throughout the operations, as well making sure the monitoring of employees' welfare. And second is referring to part 4 number 3, where I had disagreed with the company's involvement on the appointment of union officers. The company must at least stay distant and as possible not to interfere or participate on choosing or appointing the union officers. Those officers should not be appointed by just randomly selecting the person, for that way, this will lead to an issue of discrimination, because others who are supposed to be more deserving would have lost the chance on the appointment. As well, the qualification to be a union officer should not depend only on the employee's position or ranking, rather than a regular employee who has a good employment records must be the base qualification, and the appointment should be done through election or by voting process of all the union members. In that way, each one who would like to be appointed to serve the union will have the chance to be nominated and be voted. In my experience of working in different companies, especially in overseas, there is also a workers' union, but is only monitored by the company and never been interfered with any appointment decisions. And the union functions very well for the benefits of the company and its employees, which aside from HR, The union also serves as a communicating point for everyone who needs a more deeper understanding or a deeper concerns about their employment. And also, those unions are formed with rules and guidelines and in accordance to the currently implemented applicable law. To this end, conflicts can be avoided provided that any individual, groups, or organizations follow the right path of communication. Thank you.